Professor Bruce Frier is the John and Teresa Darms Distinguished University Professor of Classics and Roman Law at Michigan Law School. He is the author of numerous books, including The Rise of the Roman Jurists, a casebook on the Roman Law of Delict, and the newly published casebook on the Roman Law of Contracts. And he is the general editor of a 3-volume annotated translation of the Codex of Justinian. Also, he is the co-author of The Modern Law of Contracts, from which many distinguished law students and podcast hosts have learned. He is a member of the American Philosophical Society and the American Academy of Arts and Sciences. We had an in-depth conversation about Roman contract law. Hello, Professor. Thanks for joining us.
Thank you for having me.
Let's start by just clarifying how Romans knew what contract law was. Was it promulgated in some way, shape, or form that everyone knew what it was? Did you find out after the fact? How did Romans know what contract law was?
Well, it's actually a rather complicated question that's a little dependent on our sources, which are partial as far as ordinary Romans are concerned, very partial. The basic method was the existence of approved contract forms that operated through the edict of the Roman praetor. The praetor announced each year in advance the forms of action that he would accept. And some of these are related to contract. By no means all of them, but some of the most important ones are related to contract. This forms a kind of framework for subsequent development of the law. So often the starting point is what's recognized by the praetor's edict. This turns out to be really important for the development of contract law in particular, because very little of it originates in statute. Most of it originates from actions that were recognized by the praetor, the trials that the praetor was willing to give in order to enforce contracts between private individuals.
Yeah, that's very helpful. We talked about the praetor's edict with Professor Duplessis a little bit. So if the listeners would like any further information on that, I would commend them to listen to episode 1.
I've listened to his episode, and he certainly gives a very good account of the development of the praetor's edict. As far as contract is concerned, we fundamentally have little insight into it before about the 2nd century BCE. Thereafter, it becomes progressively more prominent in our sources. But as I stress, and we'll have to stress continuously, our sources are quite partial as far as the actual historical process that was involved.
Understood. Okay. So with that on the table, we can start getting into more substance. What form did Roman contracts take? Were they written? Were they oral? How did
they can be both. The Romans have no particular prejudice against oral contracts, and indeed, the stipulation, which is one of the central contracts that the Romans used, was oral in its form, and as a consequence, although there could be a written memorandum of it, and increasingly there was a written memorandum of it, the oral form remained part of Roman contract law right down to the end of the so-called classical period of Roman law, that is down to the late Empire. In the later Roman Empire, the later Western Roman Empire, writing becomes almost mandatory for these contracts, but in principle they always remained oral. So the Romans had a lot of trust in oral contracts in a way that may seem odd to us today. On the other hand, written contracts are certainly not unknown. Particularly under Greek influence, the Romans came to recognize the value of having a clear statement of the terms of contracts, and they frequently refer to that process.
I think non-lawyers in today's society might be surprised as to how binding oral contracts even today can be. Of course, today the when you're making an oral contract today, you don't have to be incredibly formal. You just basically have to come to an agreement. Is that correct? Whereas in Rome, it was a much more formal process when you were making an oral contract. I was hoping you could talk about that difference.
Yes, we want to concentrate here on what's called the stipulation. The word stipulation is used in a different way in Roman law than it is in modern English. Stipulation is a means, a formal means of creating a promise that's binding on the promisor, the person who makes the promise. But it has a form that involves the promisee, the person who will receive the performance, stating, do you promise to give me there's a set of words that are ordinarily used for this purpose. Do you promise to pay me 500 sesterces or words to that effect, whatever the performance is. And the other side simply says, I promise. So you have two individuals face to face, one of them stating the promise and the other saying, I promise to do that. There's no more to it than that. So it's easily recognizable. You can learn it easily. And it seems to have existed from as early as we can go back in Roman law and to have been binding. It should be noted that the promises, as the Romans would say, unilateral. That is to say, one party is making the promise and the other party is receiving the promise. And it is usually the party that is receiving the promise that is going to want to enforce it later. That is an oral form. It is perfectly possible for the parties also to write down the terms, and at least in later law, it's also possible for them to write down all of the terms and then simply say, for the promisee, simply to say, do you promise to do what is in these written terms? And for the other party to say, yes, I promise. That is to say, at that point, the written contract has become really superior to the oral form. But the oral form always remains the bedrock. And that depends to a certain extent on a general societal belief that when you give a promise in oral form, you will abide by it. You can be relied upon to abide by it.
That makes sense. I wonder if you are, say, a merchant, you might want to rely on written promises more if you're dealing in in large quantities of goods with multiple different parties. Whereas if you're, say, a laborer, build that house, there's not a lot of ambiguity in that. Was there a distinction in terms of how frequent written contracts were used in sale of goods versus in other types of contracts?
I don't know that we can generalize on that point. Usually, unlike in our law, usually even in forms that no longer involve the stipulation with its formal guarantee of a promise, the Romans usually envisage contract making as involving face-to-face transaction. So sale of goods, although it theoretically could be accomplished by letter or by an intermediary, so long as the two parties come to an agreement, usually involves a face-to-face transaction. It's just simply taken for granted that the parties will be meeting face-to-face. So there always is an oral sort of background. It's hard to generalize about what types of contracts are going to be written and what types aren't. But obviously, as contracts become more and more complicated, and in the Roman world, they could become quite complicated indeed, they're likelier to be written out so that each party knows and can use a document in later litigation.
Got it. Okay. It seems like the Praetor's edict would not be able to handle such a complicated field of law. You're starting to deal with typologies of contracts. I'm wondering where some more is it an accurate thing to say, first of all, and if it is, were jurists involved in the development of contract law?
Again, they must have been involved to some extent. The way the Romans put this is that there is this basis of this formal contract, formal in the sense that there is a required form that makes the promise binding, and then a series of informal contracts that are recognized by the praetor on a one-to-one basis, one after another over a space of perhaps 2 centuries. And these informal contracts usually involve bilateral relationships, particularly sale, lease of goods, and a lease of buildings, partnership. There's a set list of them that is likely to be pretty well known to most people who have to do business with one another. Those contracts, again, they can be purely oral. They often must have been purely oral, but there was a tendency to write them down as they became more complicated. The situation you talked about just a minute ago, where, for instance, let us imagine the delivery of wood for a building project in Rome that is going to take place over a space of a year in monthly installments. Something like that is almost certain to be written. And there's often reference to the interpretation of written terms, so we know that these contracts were written. We don't know much about how the jurists influenced the development of the praetor's edict. We do know that once that edict was in place, that is to say, once the edict had recognized the contract forms, at least in principle, the jurists were the main persons who developed the law within that contract, so that this really is quite important to the history of the law, so that if, for instance, the contract of sale was recognized, the praetor's edict gave almost no details about what that contract would have to look like, and what implications it had. And the jurists were responsible then for developing the duties that are associated with each party in one of the recognized forms of contract. They play a pretty fundamental role, and we can talk about the mechanisms that they use to develop this law, but most of the law that we know about and that seems to be enforced in the Roman Empire is in fact of development by the jurists during the 3.5 centuries from about 100 BCE to 250 CE. In which the jurists were the preeminent authorities at the city of Rome.
Got it. Okay. And again, to the listener, we talked about the jurists somewhat extensively with Professor Duplessis. So if you would like to get a good primer on what the jurists were and how they operated just at a basic level, I invite you to go and listen to episode 1. So Professor Frier, we can jump in to talking more about the jurists as it regards contract law specifically. And my understanding of the jurists is that they were sort of quasi-academic. And so they must have been thinking about contracts perhaps less concretely than the parties or even the praetor would. Did they ever develop, sort of a unifying theory of what a contract was or contract law in general? What were their thoughts on that?
They sort of began thinking about the problem of a generalized contract law because Roman law, the Roman law of contracts, develops within this scheme of recognized contracts by the praetors. It is not very amenable to a general theory. However, the Roman jurists do isolate certain elements that they deem as being common to the formation of contracts and important to the understanding of contracts. The principal one that they develop is the notion of agreement, consensus in Latin. Consensus is a idea that they describe by talking about it in terms of a meeting of the minds, that minds, the minds of the two parties to a typical contract come together like people come together to a gathering. And that's a metaphor that is explicitly developed in our sources. It's not a very helpful metaphor in that quite frequently questions arise as to whether this is an actual agreement between the parties. That is to say, whether their minds are in fact coalescing, or whether it just appears to a third-party observer that their minds have met, or whether it appears to each of them that their minds have met. And that problem is not very thoroughly examined in our sources, but it's going to continue to be a problem more or less continuously throughout the subsequent history of contract law in Europe and in the European influenced world. Fundamentally, it depends a little on where we land along a spectrum from what's called objective consent, the appearance of consent, to subjective, that is to say, real agreement between the parties. But most legal systems fall somewhere in the middle of that line, closer to the objective than to the subjective side of the equation. The Romans never really settled that problem. They probably would have been more to the subjective side of the spectrum.
That's interesting to hear that they never really settled that problem. You could imagine in sort of not sort of an antiquated litigation system with underdeveloped theories of evidence, incredible difficulty getting to subjective intent when you're talking about whether a contract was formed. And I can imagine plenty of situations where perhaps a Roman had drank a lot of wine and sold his farm as a joke. That could obviously create plenty of issues. So that's interesting to hear that they never really got around to that. But
there's a lot that's a very fair observation, and one that also Paul de Precis was making in his analysis. It often looks like the jurists are simply leaving that kind of question, particularly as it deals with evidence, to the individual judge to determine the iudex within the Roman system, rather than trying to elucidate a generalized theory. And so the question arises, is that really a better way to go about thinking of a lot of these questions? That is to say, rather than developing a fine theory that turns out to be difficult to implement in practice, whether it might not be a better idea to do what the jurist did, and namely leave a whole lot of questions like that to a iudex.
Yeah, that's a difficult thing to think through. I might think from maybe the perspective of an economist, you want settled rules so everyone knows what the expectation is going ahead of time. But then on the other hand, yeah, sort of sometimes leaving things to parties and keeping things decentralized helps grease the wheels of a market economy and keep things going.
The analysis that's being given today by economists suggests that that's not totally true, and that the way that the Romans declined to institute hard and fast rules with regard to the interpretation and the existence of contracts may have been a institutional barrier to development. The Roman jurists never really think in terms of what is beneficial to the development of a society and its economy. If you do insist on a fairly strict set of rules that are used in order to determine these questions, even though the results may be quite unfair in particular cases, such as your example of someone selling a farm because they're drunk, nonetheless, that can be beneficial for commerce. Is the argument that clear, defined rules may have the ability to move the economy forward in a way that is beneficial to the individuals in the long run, although not necessarily in the short run. Do you follow what I'm saying?
Yeah, and it sort of seems like a tricky question that you could really never resolve empirically. It seems more of a theoretical issue that's you just argue about.
I tell you, I mean, we're really on the cusp of analysis. There's been practically nothing written about all of this until roughly the year 2000. But people are quite interested in the question now of how institutions may lead the way in economic development or hinder it. And I'm actually going to be talking about that topic in relationship to banking on the coming within the next few days. So.
Wonderful, wonderful. We'll look for that. Okay, that's very interesting. We should switch gears now and talk a little bit about this concept, bona fides. Uh,
Yes, I think that's the second great concept that's
right.
associated with the development of Roman contract law. It's associated particularly with contracts, not with stipulations so much, but with other contracts, of which sale is usually taken as the archetypal example. Sale of land, sale of goods, sale of practically anything that can be regarded as property, including, for instance, accounts. The principle of bona fides is created really by the jurists, and it's thought of as a semi-public notion, a semi-societal notion that that people ought to behave toward one another with a degree of generosity, if you could put it. And it comes through in here I want to contrast Anglo-American law. It comes through in an insistence by the jurists that the parties have a duty to one another that often goes beyond what we normally require in our legal system. So that, for instance, just to give a modern example of this, when you purchase a piece of electronic equipment, you anticipate that the seller is going to have if you're buying directly from the manufacturer, is going to have a duty to include instructions that are clear. You just assume that. The Romans would have interpreted that as a duty of good faith, requiring this sort of thing. We tend to interpret it, we tend to regard it as simply an interpretation of selling, what's meant by selling. But the Romans thought of this in terms of bona fides, and bona fides is a powerful idea that has been absorbed into European civil law systems that establishes a sort of protective duty of one party towards the other. And supplements the contract with the basic contract with numerous duties that the parties are free to vary if they wish in making their contracts, but usually don't. And the consequence is to create a more social notion of contract than we are used to, and that I may have expounded to you at one point in your life.
Yes, yes, definitely. Yeah, that well, if I'm thinking, just from a perspective of custom in the United States, at least, business people, they want to have long-lasting relationships with other business people. It seems like a very intuitive concept that you're going to treat your business partner with a certain level of respect and have those, even if they're not legally binding, those obligations and duties with respect to the other party. So it makes total sense to me that that would be incorporated into law.
I think it's how it's being incorporated that's the important idea, because bona fides gave the jurists an ability to begin to think about contracts as a social practice and to the example that's given, and it's an important one, although the circumstances may seem a little odd. But you imagine someone who leaves a person, we'll call him A, leaves a deposit of money with another person B, and that person A is then subject to a criminal condemnation that involves the confiscation of all of his property. And the example that the Romans give is in that circumstance, does B have an obligation to return the deposit to A, or is it the obligation to return the deposit to the government that has confiscated the goods? And there in the raising of that question, the duty that B owes to A can be influenced by whether B has a duty to the government to carry out the government's confiscation. And the Romans seem to, at least one jurist, thinks that the duty lies to the larger social entity that is creating the contract and guaranteeing its enforcement. I think the example seems fairly mundane, but the principle that involved is really, really important. That we don't think of contractual duties and rights being entirely a matter of A and B. We also think of them in the larger social context of what contracts are for and how they are viewed by society in general. That's a major Roman contribution. They don't necessarily carry it out with complete efficiency, and it's questionable whether it should be carried out with efficiency. But they do tend to insist on this social conception of contract making that is bound to strike most modern Americans, in particular, as strange.
That does sound strange on the surface level, but it makes. I mean, we very frequently resort to public policy justifications for certain parts of contract law, and that seems like it's a species of that, where you're saying we have this contract law. Yes, it's you're talking about a relationship between two people, but we're viewing the actual law with respect to the entirety of society. So that's very interesting to hear that example. So you mentioned that the jurists helped develop the theory of bona fides, and that they were sort of a driving influence in getting it into law. I'm wondering if you could just talk a little bit mechanically about how that happened. Um, where did they get the idea from, and then how did they put it into law?
Certainly. The formula, the easiest way to look at this is to go back to the Praetor's Edict and look at the formulas that were used in order to enforce contracts. The formulas for sale, there's one for the seller and one for the buyer, but they are almost identical in their wording, except for the changes that in the difference in position enjoined. The formulas contain a reference to whatever it was that the defendant was obliged to do ex fide bona, on the basis of good faith. And undoubtedly, or at least it's thought this way by most legal historians, undoubtedly, originally this meant sticking to one's word. Fides is a Roman concept that is used very widely in Roman sources, and that is thought of in terms of the duty to carry out one's word faithfully. To do what it is that one promises is a legal application of that notion, and that notion then becomes enforceable in the context of law. So the seller is obliged to carry out his word, and as a consequence is liable in a court for failure to do so. But the jurists took this phrase and began to interpret it. And here it's quite clear that they, or at least it's thought to be clear, that they were departing from the original intention in the wording of the formula, and were instead beginning to develop it in this broader social way that I suggested. This is a process of interpretation that's not at all dissimilar to the sorts of interpretations that occur with regard to fundamental concepts in, for instance, the Constitution of the United States or whatever. But it has far-reaching consequences. The general duty of both parties to adhere to a notion of good faith is a juristic development and it allows the jurist to create duties pretty widely. Some of the most important duties include, for instance, the duty of a seller to warrant the non-existence of latent defects in the object of sale. Those kinds of duties are imposed by the jurist on the basis of this wording, ex fide bona, on the basis of good faith. And so the wording thus has enormous consequences for the ramification of contract law within the Roman world. It's continued to have a very prominent role in subsequent legal systems as well. It's used in all kinds of ways to create duties and liabilities in, for instance, German or in French law. Where the court is, in a way, kind of legislating for the parties, but is nominally just applying this notion that the parties are bound to one another by ties of good faith. This goes way beyond the notion of good faith in our legal system, which is a much more restricted category of duty. And so European law has accepted this much broader notion as being what it is looking for when it examines the conduct of the parties towards one another.
That's really fascinating. This might shock the listener to hear, but I have not studied the interpretive development of bona fides in any great depth. So I'll ask you, Professor Frier, do you think that the interpretations or the development of this concept, do you think that the interpretive moves were fair? Do you think that they were contrived in some senses? Were they natural? What's your sense of that?
In some ways, in some places, you can certainly say that it looks to be a little contrived, but I think basically, and this goes along with something that Professor Duplessis said as well, that basically the jurists seem to look for a fair balance between two parties. There's been an effort by scholars, for instance, to suggest that in some areas of law, one party would have been predominant over another. And that certainly is possible within the realities of a marketplace. But the jurists seem, by and large, to have ameliorated that division of wealth, of power, by looking for fair solutions. It's questionable. It's sometimes difficult to know whether the jurists are doing the right thing or not, and their decisions can easily be questioned. But I think largely the jurists seem to have a very good sense, for instance, of the influence of money on the way that on the way that the social world operates. So, yes, I by and large, I think they aim for fairness. They aim for what the jurist called equitas, what Roman society is large called equitas, which means fairness in its core meaning between the parties to lawsuits.
Well, then that's good to hear. So that's all very, very interesting. But I think we should shift gears now to obligationes, which my understanding of it is, and correct me if I'm wrong, is sort of a more general concept within which Roman contract law fits. And I'm hoping you could talk about this concept.
I think obligatio is a notion that one party is tied to another. That's the formal metaphor that is used to describe a relationship in a way that is, for instance, not true of property, and at least in Roman law, of property relationships. There, the relationship is of an owner or of a possessor with a piece of property, directly with the piece of property. In obligations, the relationship is of one party to another, and it is created. This is a sort of super concept that is mentioned and discussed by the jurists, probably not as important in the general law of Rome as it would be in later law. But obligations are typically divided into two broad groups: contractual obligations, which is what we've been discussing, and then what are called delictual obligations, obligations arising out of wrongdoing, of which damage to property or damage to the person, injury to another person's personality or body can be regarded as another. The separation between them is recognized from an early date, but because they're all grouped together under this broad concept of obligation, they have an influence on one another in a way that is not typical of our legal system. In our legal system, torts and contracts are held separate from one another. You take them in two different courses, and they jar with one another in some important ways. So that typically a lawsuit, for instance, over a dangerous what turns out to be a dangerous chemical that has been released into the public, let's say a lotion that turns out to affect some people very adversely, can have both contractual and tort implications. But the Romans and systems that are derived from Roman law tend to see those two different types of claims merging together. Obligation, therefore, is a very powerful concept potentially. The Romans don't really develop it with full vigor, but it does have a lot of influence on details of the systems that they devise. I don't know if that's helped. When one's talking about obligations, one really is at a fairly high level of juristic abstraction, and the jurists are quite good at that.
Right. That is very helpful. I think Professor Don Herzog in my 1L year said that breach of contract is just a tort. And that can kind of give the same. You may disagree with that as a contracts professor, but that kind of gives the same sense of these are two aspects of the same, or two sides of the same coin, I'll say, where you have an obligation to another person, and whether or not it's hurting them or what you owe them because of a contract, it's the same exact thing. It's just we study it in depth in two different classes, essentially.
Yeah. However, what goes on in those two different classes is quite distinct. Normally, a contract obligation in our system is accompanied by what is often called strict liability for the failure to carry out the contract. So that coming in and saying, well, there were circumstances beyond my control that made it impossible for me to perform, is not going to be heard as an argument in most cases. There are circumstances in which breach of contract, if it's deliberate and intentionally harmful, can be a tort. But basically, we tend to regard the two as in separate categories. And when you get down into the point of detail, for instance, in theories of causation and so on, the distinction is real. I don't think of breach of contract as a tort, and so I'm always reluctant to disagree with Don Herzog, who is a very skilled both in thinking and in arguing. But in this case, I'd venture to say that he's just plain wrong.
And I hope to God that I did not misrepresent his position. He might have been saying it provocatively, so I'll just put that.
He is known for being provocative.
Yes, definitely, especially in class. Okay, that's all very helpful. I think we discussed a little bit whether or not the jurists were really thinking in economic terms, and I think we said basically they weren't at all, or maybe they were slightly, but it wasn't the main point of their thinking. But I would like to just discuss how the development of contract law helped to develop the Roman economy. Do you think that the development of, I'll just ask, do you think that the development of Roman contract law helped develop the Roman economy?
I think probably it did on the whole, despite all of the difficulties for instance, the implementation, we started by talking about how did people know what contract law was. Knowledge of law is not very systematically diffused in Roman society, but gradually becomes more established as time passes. Economic development as it relates to institutional development is a difficult question, but normally speaking, we think that as legal rights become clearer, as people can have more confidence in them, that economic development is likely to be encouraged. That is to say, instead of spending their money on relatively ephemeral ends, people will tend to invest and to think about long-term profit. The catastrophes that are currently undertaking the Bitcoin industry show that people are not always wise about how they invest their money. But at any rate, the institutions can pretty clearly tell them that if they invest it unwisely, they may not be protected, so that the risk is on them when they do that. The risk is reduced by the clarity of the legal rules, and by and large, that's regarded as beneficial to economic development. However, the details of all of this, as I said, are only recently being worked out. And there still is a lot of room for debate about exactly how development is related to institutions. I think, and the jurists can probably be said on the whole to have been beneficial by working out this system of rules, even if it is not always optimal from the perspective of economic development. On the other hand, it needs to be said just emphatically, the Roman world, the Roman economy never really takes off. And that may in part be due to the way that the Roman contract system was set up with all of these various contracts. There were contracts that fell through the gaps. There were difficulties that arose in the creation of firms, of businesses that seem to have inhibited growth, probably.
Yeah, and one thing that you jumped out that jumped out to me earlier that you said was you mentioned that contracts were by and large a face-to-face affair. So if you're trying to build an economy for the entire empire, that's an incredibly limiting thing to have. You're only doing business essentially within the city, or if you're traveling, you got to travel a long distance.
Recent studies by particularly, there's a German scholar who's worked extensively on this, tend to suggest that when you look at Roman businesses, they were they could be reasonably sophisticated. They make good use of the fact that many slaves, for instance, were quite skilled at business, but they were shallow. They don't show a great. Usually, they're limited to between 1 and 5 people. They're small by our standards, and the development of a sort of tiered business system doesn't seem to occur except in rare instances, and that really is important. The lack of vertical development means that that firms were unstable, relatively prone to insolvency in a way that that renders the business climate less than robust.
Right, and one doesn't need to be a great scholar of Rome to see the contrast with the Roman military, an incredibly a more I shouldn't say incredibly a more developed, more hierarchical system than businesses. One's going to run way in front of the other, so that's a very interesting contrast.
Indeed.
Yes, one you mentioned slaves, and I'd like to ask about that. Did Roman contract law encourage the use of slaves in any way? Was slavery important to Roman contract law in any way?
Yes, I think slavery figures pretty heavily in the Roman economy, and there's a lot of debate still about whether slavery was in the end a net positive or a net negative as far as just the economy is concerned. I'm not talking about the moral aspects of it, but um, it was a pretty brutal system for most slaves. But for a certain number of slaves, it was actually a system that allowed them the ability to build considerable economic power in relationship to an owner, and they could carry that power across to their lives after they left. I think the more difficult thing from a legal point of view is to figure out how to link the slave to the slave manager, for instance, of a small business, how to link the manager to the owner such that creditors would not be put off by the fact that the slave actually has no property of his or her own. And that's a major legal accomplishment. It involves cooperation between the praetor in introducing new forms of action that allow for creditors to go against the owner of the slave um, directly rather than having to go through the slave. Uh, and um, and the development of those mechanisms. Uh, I don't want to give the impression that this body of law is perfect. The Romans never work their way, for instance, through a theory of agency, where the slave becomes simply the legal extension of the owner. But they did substantially recognize the capacity on the part of owners to begin to develop businesses using slaves as a sort of extension in a weak sense.
That's very interesting, and obviously a huge topic. We're running up close to an hour here, and I don't want to take up too much of your time, but it would be a shame if I didn't ask you about damages, and we can end with damages like any good contract law class. I was hoping we could first get a sort of an account of what damages were, or what sorts of damages there were in the Roman legal system. Um, yeah,
As I think Professor Duplessis mentioned, the damages are not the award at the end, the remedy that's given at the end of a contract action is normally expressed in monetary terms, so that what's called the monetary condemnation of the defendant, and that means that it is often rather difficult to I mean, apart from the court saying that the defendant owes this much money to the plaintiff, um, there is not much in the way of remedy that goes beyond that, and this surely reflects, as Professor Duplessis said, surely reflects upon the inadequacy of the court in, for instance, requiring that the defendant transfer property to the plaintiff apart from the monetary condemnation. Um, there's limited capacity for something that substitutes. For instance, some of the forms of action allow the judge to give a monetary judgment in excess of the value of the object that's involved um, as a practical effect, and thereby to sort of um, force the defendant to surrender property indirectly. But the system is quite weak as far as its ability to carry out what we call specific performance. Um, the one thing I would say is that nonetheless that the Romans are quite skilled in thinking about money and how to handle this problem. And they develop, for instance, good rules with regard to restitution. And so, for instance, in many circumstances where, for instance, a buyer has paid in advance for something and and the seller has not then delivered, the buyer may prefer restitution as a remedy. That is usually not possible, but there are circumstances in which it is possible, and the jurists think about that actively.
That's very interesting. And it's interesting to hear about specific performance not generally being available. We did talk about that with Professor Duplessis a little bit, and I'm looping this back to the development of the Roman economy. My understanding is that specific performance is usually disfavored as an economic matter, that it's not thought of as beneficial economically as just getting the money. So that might actually inadvertently work out in the favor of the Roman economy, that they used
Yeah.
money for their damages.
And as the Roman economy developed, particularly after in the second century BCE, as the Roman economy developed, the sorts of lawsuits that came up were often susceptible to control via money. That is to say, money gives law, as has long been recognized, a capacity to deal with parties in a way that, for instance, an economy based on exchange doesn't, on the exchange of goods doesn't, a barter economy. And the jurists certainly take advantage of that. They are fully aware of it. This is important because large sectors of the Roman economy were probably not monetized in fact, but that would accord with what we know about underdeveloped countries generally. But the law tends to cater to those sectors that were more commercially advanced, and that's pretty plain in the text that we have surviving to us.
Okay, that makes sense. I'll ask you one more substantive question, and I promise I'll let you go. I have to, unfortunately, again, abstract this and talk about obligatio. I'm wondering if the concept of obligatio informed how Romans thought about damages in any way.
Yes, a little. Uh, Again, it doesn't make any difference whether contract or delict, that is to say, tort, is involved. The condemnation is always in terms of money. Um, I don't know. It may have influenced it a little. It's a good question. I'm not absolutely sure of the answer to it. The jurists don't go as far as we would have liked them to have gone in specifying how one looks at damages. They're aware of measuring the loss to the plaintiff in terms of markets, but they don't do a very good job of expressing the idea. They are particularly weak when it comes to the extent that a damaged party, the victim of a breach, can go after not only the direct losses associated with the economic exchange, but also losses resulting from the breach of the contract. So that if I buy beams from you, roof beams from you, and the beams turn out to be rotten and my building collapses, can I recover not only for the beams themselves, but also for the collapsed building? Um, and they make some struggle in order to arrive at a just solution of that, but and their efforts are informed by other areas of the law, but I'm not sure that obligation helps much one way or the other as a generalized concept.
Yeah, I think what I'm wondering, I think that there's a tendency, say maybe law and economics people today, they'll think of I might just end up cutting this out because I'm completely mischaracterizing law and economics, but they think of breach and damages and remedies more in terms of what is more efficient and what is more
Yes.
optimal in general.
Yeah.
Whereas I'm wondering if Romans, they thought of damages as you had this relationship with this person, you wronged that person, so therefore you have to make them right. Was that sort of more the theoretical basis for damages? Would you say that's fair?
I'm not sure either of those concepts is going to be completely good to uh, um, making the plaintiff whole might often involve a consideration of damages resulting from monetary damages resulting from the breach in contract. As I say, that was an area in which the jurists were weak. Usually, decisions on damages are left pretty much in the hands of the Iudex, as it seems, rather than being spelled out as a system by the jurists. So they're quite good about talking about duties, for instance, and rights of the parties as a consequence of a contract, but rather weak about talking about what happens when those rights and duties get into a court. Um, while the damages are often defined in terms of what's the Latin expression is id quod interest, the interests, the financial interests of the plaintiff, um, the extent of those interests is often left quite murky in our sources, as if there was an uncertainty that was going to have to be filled in by the judge at the time that a decision was rendered. My own view is that the jurists deliberately abstain from this question. As you will know from first-year contracts, our law was quite late in arriving at a concept of consequential damages for breach of contract. Not really until after the Industrial Revolution was well underway. And it might seem that that's just an obvious necessity, but many legal systems, pre-modern legal systems, haven't thought of it as a necessity and simply allowed it on a case-by-case basis. That seems to have been the Roman solution.
Okay, that makes a lot of sense. Okay. I won't ask you any more questions other than do you have anything coming up or anything that you're working on that you would like to plug for the audience?
Not really. I've begun working on I've been quite interested in law and economics problems more generally. I've begun working on the law of dowry, which is not very deeply studied from this perspective. Dowry is an institution that that requires the bride's side to provide an agreed upon amount of property to the groom's side in the making of a marriage. And then that property has to be returned to the bride's side if the marriage ends through divorce or through the death of the husband. But if it's through the death of the wife, it usually stays with the groom's side. Um, During the marriage, all of the income from the property stays with the husband. That is to say, it is his property. He is not required to use that property in a way that benefits his wife during the course of the marriage. That's the basic description of the institution, and it has all kinds of economic implications. It's just an unusual institution that the Romans handled with considerable skill. The jurists handled with considerable skill in thinking about how to protect both parties to the arrangement from the potential either for the husband to be less than fully diligent in protecting the bride's interest, or for the husband actually to be duplicitous in the handling of the money. And those were difficult questions. And the jurists did the best they could within the structure of Roman institutions to provide a solution. As I say, I'm just getting into this subject. I was working on contract law previously, but we do know from Cicero that dowry was regarded as a major method for the transfer of wealth between families, alongside sale and inheritance.
That sounds very interesting and very useful. So we'll keep an eye out for your work. Thank you for joining us, Professor Frier, and take care.
It's been my pleasure.